Hello everyone, welcome to Oliveboard. So in this particular session, we are going to discuss about the MCQs related to the Companies Act for your SEBI General Examination Phase 1. तो ये मिक्स में रहने वाला है, ये Phase 1 के भी MCQs हैं, ये Phase 2 के भी MCQs हैं और दोनों ही आपके एग्जाम के लिए डेफिनेटली रिलेवेंट हो सकते हैं फॉर द अपकमिंग SEBI Grade A examination, right? So we'll be going to discuss a lot of questions here from the Companies Act. Almost हम सारे चैप्टर में से, सारे टॉपिक्स में से आपके काफ़ी सारे क्वेश्चंस यहाँ पे डिस्कस करने वाले हैं, तो वीडियो के एंड तक बने रहिएगा. कोई भी क्वेरी हो तो यू कैन ऑलवेज लेट मी नो इन द कमेंट सेक्शन, राइट? आई विल बी मोर देन हैप्पी टू हेल्प यू गाइज. सो आप साथ में क्या कर सकते हो, साथ में आप एक बढ़िया रिविजन कर सकते हो इन क्वेश्चन बेस्ड फॉर्मेट के अंदर, राइट? और साथ ही में मैं आपको क्या सजेस्ट करूंगा कि जैसे आप ये लेक्चर कंप्लीट करते हो, आप मेन प्रोविजंस अपने कंपनीज एक्ट की भी रिवाइज कर सकते हो इसके जस्ट बाद. तो आपका यहाँ पे बहुत एक बड़ा कवरेज होने वाला है इस लेक्चर से. ओके, सो लेट्स स्टार्ट द डिस्कशन गाइज. लेट्स स्टार्ट विद क्वेश्चन नंबर 1. What is the minimum number of members required to form a public company? A very basic question, a very simple one. What is the minimum number of members that I need in order to form a public limited company? So I need bare minimum 7 members, right? I need bare minimum 7 members as per section 3 related to the formation of company. I need bare minimum 7 members to start a public company. Right? Tell me this one. As per the private companies, a private company means a company, option A, that prohibits any invitation to the public to subscribe for any securities of the company. Option B has a minimum paid up share capital of 1 lakh rupees or as may be prescribed. Option C, by its articles, limit the number of its members to 200. All of the above or both A and B? What do you think will be the right choice here? Take your time, read the options and let me know. The correct choice, guys, here will be option A, which prohibits any invitation to the public to subscribe for any other securities, right? Has a minimum paid up capital of 1 lakh rupee. Is it so? Is private companies having a bare minimum capital of 1 lakh rupees? What do you think? Is this the correct answer? What is the paid up capital requirement? What should be the paid up capital requirement here? So check this one later on. What is the paid up share capital requirement? What is the minimum number of member requirement, maximum number requirement also? Acha, tell me this one. Here we are going to discuss about the associate company. What do you mean by associate company here? We say that associate company is having a significant influence, right? Associate company do have a significant influence. So if we talk about an associate company, which is in relation to another company, means a company that is a holding company has a significant influence here, right? But which is not at all a subsidiary company, Yes, the correct answer here will be 20%, at least 20% of the voting power. So we have discussed this in a chart format. This is 0%, this is 20%, this is 50%, and here we have 100%. So here if I talk about the associate company, it starts from the holding of 20%, right? So this area is of associate company. You are a holding company. If you are having at least 20% or more than 20%, then this is your associate company. If you have more than 50%, then it will be your subsidiary company. This will be your subsidiary company. And what if you own 100% of it? It will be a wholly owned subsidiary company. It will be a wholly owned subsidiary, right? That's a wholly owned subsidiary. So here option C will be the right choice. Can you tell me the maximum number of directors in a public company? Maximum number of directors in a public company. What do you think about this one? How many maximum directors I can appoint in a public company? Here we are talking about public company. Maximum number of directors in a public company, yes. That is 15. Perfect. That is 15. Now tell me, I want to appoint more than 15. Is it even possible? I am having a public company. I want to appoint more than 15. Is it even possible? And if it is possible, whether this requires a board resolution, ordinary resolution, special resolution, or A or B, or B or C. First tell me, is it possible? If it is possible, what resolution I need to pass? I am a public company. I can appoint 15 directors maximum, but I want to appoint, let's suppose, 16 directors or 17 directors. Then in that case, what I need to do here is, yes, I need to pass a special resolution for that, right? I need to pass a special resolution for that. So here we have studied, this is in section 149 related to the board of directors. Minimum 3 directors I need in case of public company, 2 directors in case of private company, 1 director in case of one person company. A company can appoint maximum 15 directors. If you still want to go above 15, then you need to pass a special resolution, right? Then you need to pass a special resolution here. The amount payable on the application on every security shall not be less than what percentage of the nominal amount of the security as per the Companies Act 2013. The amount payable on application on every security shall not be less than what percentage of the nominal amount of the security as per the Companies Act 2013. 2.5%, 5%, 7.5%, 10%, or 15. Yes, Sachin, that's perfect. Good afternoon, Nancy. No problem at all. So here the correct choice will be 5%. Okay, 5%. The application money, let's suppose your share is worth rupees 100. So at least you need to ask on the application money. On the application money, you need to ask at least 5 rupees, right? It should be bare minimum 5% of the nominal amount. What is your nominal amount? It can be face value, it can be par value, or it can be nominal value. One of the same thing only, right? One of the same thing only. Next one, a company limited by share is a type of a company where the liability of its member is, option A, limited to the amount paid on the shares held by them. Option B, unlimited to the amount unpaid on the shares held by them. Unlimited to the amount unpaid, if any, on the shares held by them. Limited to the amount unpaid, if any, on the shares held by them. Or to the amount up to which each member undertakes to contribute. So the question is all about, let's suppose I have a share worth rupees 10. I have already paid 4 rupees. I'm yet to pay 6 rupee, right? So 4 rupees my paid up. This is my 6 rupee which I'm yet to pay. How much will be my liability as a shareholder? How much will be my liability as a shareholder? Sorry, I was on mute. Sorry. My liability will always be limited, right? My liability will always be limited. Why? Because I'm a shareholder in a company and the company is formed on the concept of limited liability, right? So limited to the amount unpaid, if any, on the shares held by them. So if I haven't paid any amount, my liability will always be limited. Which of the following is a new type of company which was introduced by Companies Act 2013? Now this is not a new question. ठीक है, इस क्वेश्चन को टाइम हो गया, कंपनीज एक्ट को आए हुए भी बहुत टाइम हो गया. Still, in one regulatory examination it was there. Which of the following is a new type of company which was introduced by Companies Act 2013? Yes, it was OPC. It was one person company, right? It was one person company which was introduced by the Companies Act 2013 for the first time. Okay, that's fine. Tell me the maximum underwriting commission that can be paid by the company for issue of debentures, which should be dash percentage of the issue price of debenture. Which is 2.5%. Perfect. 2.5% of the issue price of the debenture. 2.5% here is the correct choice. Okay, that's the correct choice. Next one. Can you also tell me about the maximum underwriting commission that can be paid by the company for issue of shares? What percentage of the issue price of the share? Here we talk about share. In the previous question, we were talking about debentures, right? This is shares. The correct choice is 5%, right? The correct choice is 5%. So we have discussed here. In case of shares, you can pay up to 5% of the issue size or the rate authorized by the articles of the association, whichever is less. In case of debenture, 2.5% or the rate authorized by the articles of association, whichever is less. Now, this is a direct limit-based question. They can ask you one more question like this. For example, a company is paying the underwriting commission on debentures, right? So they want to pay 2.5% commission. Or let me just take this example. They want to pay 3% commission and it is permitted in the AOA. And it is permitted in the articles of association. Can they pay this much amount of 3%? Because here the formula is 2.5% or AOA authorization, whichever is less. Please do remember this thing. You can't go above a certain percentage here. Why? Because they have restricted you. But let's suppose a company wants to pay a commission of 2%. But the AOA authorization is just 1% here. What will be the case now? Whichever is less, 1%. But sir, the limit is 2.5%. Doesn't matter. Your company is restricting you at 1% because it is stated clearly in articles of association, and we have to follow the rules and regulation of the company, right? We have to follow the rules and regulation of the company. AOA is nothing but internal rules and regulations that a company needs to follow. Acha, what do you guys mean by underwriting? Anyone? What's the meaning of underwriting here? What do you mean by underwriting? Yes. So we can say that, let's suppose I'm going for an IPO. I have 1 lakh shares. Now there can be multiple situations. Fully subscribed. I got the applications for, let's suppose, exactly 1 lakh shares. I got the applications for exactly 1 lakh shares. So I will call it as fully subscribed, right? The application is fully subscribed, 1 lakh shares. I received the applications from the 1 lakh applicants, right? What if I received the applications from 1,20,000 shares? I received the applications for 1,20,000 shares, but I can offer up to only 1 lakh. So this is called as oversubscription. This is called as oversubscription. But what if the real risk is getting only 80,000 applications for the shares? This is called as undersubscription. This is called as undersubscription. In the name itself, it is mentioned underwriter, right? Underwriter. So in case of undersubscription, underwriter is there to protect you. Underwriter is there to protect you. Rest of the 20,000 rupees, it is the underwriter's responsibility to buy the rest of the 20,000 shares. Right? Next one. As per the Companies Act, when the directors are required to make disclosures of interest, when the directors, let's suppose I am a director in a company and I am an interested director. I am an interested director as per section 184. Then in that case, when do I have to disclose my interest? When do I have to disclose my interest in the meeting? When I have to disclose my interest in a meeting? So B, C, or E. So what happens is, let's suppose I'm a director. I'm participating in the meeting for the very first time. I'm participating in the meeting for the very first time. So this is my first meeting. This is my first board meeting. In the very first board meeting, I need to tell you that I am an interested director. And thereafter, every financial year, in the first board meeting, I have to again and again tell that I am the interested director. So the correct option here will be option E. Both B and C. Both B and C are correct, right? Both B and C are correct. Why? Because the interest can change. The interest can change with time. And so I have to again and again disclose it. Right? Maybe I'm not an interested director in the next board meeting, or maybe I'm interested in multiple companies in the next board meeting. So in every first board meeting, in every financial year, I have to disclose my interest. Next one. A small company is a company whose paid up share capital and turnover shall exceed 2 crore and rupees 10 crore respectively, shall exceed 4 crore and 40 crore, shall not exceed 4 crore and 40 crore, shall not exceed 10 crore and 100 crore, or none of the above. This is regarding the small company. Definition of small company. Now those who are giving the answer D, they must have studied this very well, or they just saw my post in the morning only. So the correct answer here, guys, is option D. A small company is one whose paid up capital should not exceed 10 crore rupees and turnover should not exceed 100 crore rupee. Why? Because the definition of the small company is now revised. Okay, it is now revised with effect from 1st of December 2025, and this is a very high probability question. This is a very high probability question for your examination, for your upcoming SEBI Grade A एग्जामिनेशन, राइट? ये बहुत हाई प्रोबेबिलिटी है, डायरेक्टली आपके एग्जाम में आ सकता है. ओके, अच्छा, इसके अंदर क्या होगा? काफी सारे लोग 4 करोड़ और 40 करोड़ मार्क करके आ जाएंगे, क्योंकि अर्लियर ये ऑप्शन सी हुआ करता था, राइट, जो कि अब हट चुका है और ऑप्शन डी आ चुका है. सो जो मैक्सिमम लिमिट थी वो टच हो चुकी है अभी यहाँ पे, राइट? द रिवाइज लिमिट्स आर एज फॉलो. द पेड अप शेयर कैपिटल इज नाउ 10 करोड़ विच वाज अर्लियर 4 करोड़, and the annual turnover is now up to 100 crore, which used to be 40 crore. So these are the new limits. Okay, these are the new limits. And guys, this can be one of the most important question for your examination. And those students who are not studying for the amendments, they can miss this particular question. ये phase 1 में आ सकता है, phase 2 में भी आ सकता है. ठीक है, ज्यादा चांस है कि ये phase 1 में अभी का अभी आ सकता है, क्योंकि नया अमेंडमेंट है. ठीक है, नया अमेंडमेंट है और इसमें फेज 2 में आने लायक वाली कोई बहुत ज्यादा खास बात है नहीं, राइट? So the revision is expected to bring a substantial number of additional private companies, particularly startups and MSMEs within the ambit of small companies. So सिर्फ MSME के लिए ऐसा नहीं लिखा हुआ है ना, सिर्फ MSME के लिए ऐसा कहीं नहीं लिखा हुआ है. देखो, स्मॉल कंपनी का तो डेफिनेशन होता है, उसमें कोई भी आ रही हो, डजंट मैटर, राइट? ठीक है, और बहुत इंपॉर्टेंट है, हो सकता है इस बार फेज 1 के अंदर आ जाए, नहीं तो हो सकता है फेज 2 के अंदर आ जाए. मुझे ऐसा लगता है फेज 1 में ही आ जाना चाहिए, क्योंकि स्ट्रेट डेफिनेशन है ना. बायबैक विद बोर्ड रेजोल्यूशन इज अलाउड इफ द अमाउंट इन्वॉल्व्ड इज व्हाट? नॉट एक्सीडिंग 25% ऑफ द टोटल पेड अप कैपिटल एंड फ्री रिजर्व्स ऑफ द कंपनी, नॉट एक्सीडिंग 25% ऑफ द टोटल पेड अप कैपिटल, not exceeding 10% of the total paid up capital and free reserves of the company, not exceeding 10% of the total paid up capital. Take your time and answer the question. Take your time, आराम से, and answer the question. The correct choice, guys, here will be option C, right? Option C here is the correct choice. Why? Because you have to make the buyback, that too with the board resolution. So if you are making a buyback as per section 68, the board resolution is fine if it is up to 10% of your paid up capital plus your free reserves. plus your free reserves. If you want to go above that, then you need to pass a resolution in the general meeting, right? Then you need to pass a resolution, special resolution in the general meeting if it exceeds more than 10%, but up to 10% it is within the power of BOD. A special resolution, okay? Special resolution 25 तो maximum है, 25 से तो you can't cross in one financial year, सही है ना? So 10% से ऊपर जाना है तो यहाँ पे आपका स्पेशल रेजोल्यूशन लग जाएगा. 10% तक हो तो फिर तो बोर्ड ही कर देंगे. Under the Companies Act, a company may advance any loans or give any guarantee or provide any security in connection with any loan taken by any person in whom any director of the company is interested, if there are certain conditions. Read the options and let me know. Now this is from the section interested director. Yes, option D is the correct choice, right? A special resolution is required in the general meeting, right? And C, the loans are utilized by the borrowing company for its principal business activity. This is a must. You need to utilize it for the principal business activity only. We have studied this one. Can you guys tell me what do you mean by a nominee director? What is the meaning of a nominee director? So guys, if we talk about nominee director here, option E will be the perfect choice, right? So as per section 149, a company to have board of directors. If we talk about the nominee director, explanation means a director nominated by any financial institution in pursuance to the provision of the law for the time being in force, or appointed by government or any other person who is representing the interest. So यहाँ पे दोनों आंसर करेक्ट हो जाएंगे, राइट? बट एज इट इज अगर ये क्वेश्चन एग्जाम में आ गया, तो किसको टिक करोगे? ऑप्शन ई को, राइट? आंसर बोथ ऑप्शन ई एंड ए ही है, राइट? सो इट्स अ डिफेक्टिव क्वेश्चन, इट्स अ काइंड ऑफ डिफेक्टिव क्वेश्चन. बट अगर डायरेक्टली एग्जाम में आ गया तो मैं ई को टिक कर लूंगा, राइट? वो मोर सुटेबल हो जाएगा ऐसे केस में. बट यस, दिस इज अ फॉल्टी क्वेश्चन आई कैन से. Next one, can you guys tell me how many schedules are there in the Companies Act 2013? Now, if you know the structure of Companies Act 2013, if you have studied this from the notes, you can easily answer. How many schedules are there in Companies Act 2013? 3, 4, 5, 6, 7. Okay, Shreyansh, Nancy, option C, okay. What about others? Sorry, option E. Yes, option E here is the correct choice. We do have 7 schedules, right? We do have 7 schedules. Acha, can you guys tell me which is the schedule in which we prepare the balance sheet and the P&L account? This can be important. Which is the schedule in which we prepare your balance sheet and P&L account? Out of the 7 schedule, what is the number? Yes, that's third schedule. That's the third schedule. Where the depreciation rates in the Companies Act are given. In which schedule the depreciation rates in the Companies Act are given? This is another question that can come up in the examination. Where they have given you the depreciation rates. There is a schedule for that also. Yes. When we talk about depreciation, it is schedule 2. It is schedule 2, and when we talk about balance sheet, profit and loss account, it is schedule 3. Okay. So have a look at the table later on for the reference purpose. Next one, a very simple question. The first auditor of a company other than government company shall be appointed by the dash by whom within 30 days from the date of registration of the company. It's a very straight one. Which schedules are important from that chart? So those that I have asked you right now, 2 and 3, most important. Most important are 2 and 3, but later on just give it a quick reading about the schedules. Here the correct choice will be Board of Directors. Now, if I talk about what schedules they can directly ask, they can ask anything in the examination. Obviously, they can even go out of course for at least 1 or 2 questions. एक क्वेश्चन में तो वो आउट ऑफ कोर्स भी जा सकता है, बट अगर मुझे लगता तो मैं आप लोगों को बोलता कि स्केड्यूल 1 पढ़ लो, मेमोरेंडम आर्टिकल, स्केड्यूल 2 बहुत इंपॉर्टेंट है, स्केड्यूल 3 बहुत इंपॉर्टेंट है क्योंकि ये दोनों तो आपके कोर्स में है, राइट. देन कॉर्पोरेट सोशल रिस्पॉन्सिबिलिटी वाला भी पढ़ लो. ओके, सो दैट विल ऑल्सो बी फाइन. दैट विल ऑल्सो बी फाइन. अगर आप इतना पढ़ते हो तो भी एक बार काफी अच्छा रहता है, पर पूछने में वो कुछ भी पूछ सकते हैं एग्जाम में. अभी मना कर दूं कि नहीं और कुछ नहीं पूछ सकते और फिर पूछ लें तो फिर भी इशू है, राइट. फिर और बड़ा इशू है कि सर आपने तो मना किया था, बाकी तो हम ये भी पढ़ लेते. सो इसलिए मैं बोलता हूँ यार कुछ छोड़ो ही मत, कुछ छोड़ो ही मत, राइट. बट यस, अगर मैं होता तो मैं ये वाले पढ़ रहा होता डायरेक्टली. मैं होता तो मैं डायरेक्टली पढ़ रहा होता. ठीक है, मेरे को पता था ये वाला क्वेश्चन आएगा सर. 1, 2, 3 तो डिविडेंड का स्केड्यूल है, उसके अंदर ही एक एक्सप्लेनेशन दे रखा है डेप्रिसिएशन के स्केड्यूल का भी, राइट. सो बिकॉज वी हैव सो मेनी सेक्शंस इन 123, in a subsection there is an explanation related to the schedule 3 as well. yes, सेफ साइड रहने के लिए मैं होता तो मैं ये वाले स्केड्यूल्स पढ़ लेता. ठीक है, क्योंकि ये थोड़े से रेयर है. ये जो 4th, 5th और 6th वाले जो हैं ये अभी तक थोड़े से रेयर है, और ये अभी तक मैंने किसी और रेगुलेटरी बॉडी एग्जामिनेशन में देखे नहीं है. अभी तक जितने भी प्रीवियस ईयर क्वेश्चन मैंने देखे हैं पिछले 5-5 सालों के, मैंने ये वाले क्वेश्चंस अभी तक देखे नहीं इनके ऊपर. और डेफिनेटली थोड़ा सा अनफेयर भी हो जाता है जब एग्जाम में पूछते हैं. इट्स नॉट रिक्वायर्ड ये वाले क्वेश्चंस पूछने के लिए, राइट. 4th, 5th और 6th जो रहता है वो डायरेक्टली आपके एग्जाम में फॉल भी नहीं करता, और इट विल बी टू डीप अगेन. बट 1, 2, 3 एंड दिस वन इज फाइन. कॉर्पोरेट सोशल रिस्पॉन्सिबिलिटी वाला इज फाइन. ओके, वो आपको आना चाहिए. So here the correct answer is Board of Directors, guys. Right. Next one. A company shall not at any time vary the terms of the contract referred to in the prospectus or object for which the prospectus was issued, except subject to the approval of or except subject to an authority given by the company in general meeting by way of what kind of resolution? अब भाई सेफ साइड रहना पड़ता है श्रेयांश, नहीं रहूंगा, बोल दूंगा छोड़ दो, आ गया एग्जाम में तो गाली में खाऊंगा, राइट, नहीं पढ़ाऊंगा तो गाली में खाऊंगा, तो इसलिए सेफ साइड थोड़ा सा रहना पड़ता है, इसलिए मैं थोड़ा सा आपको कंटेंट ज्यादा ही देना प्रेफर करता हूं, बट एट द एंड दे कैन गिव यू वन क्वेश्चन ऐसा जो आपके कोर्स से बाहर हो, ठीक है, भले ही आप सारे के सारे कोर्सेज खरीद लो मार्केट के, तो भी एक आध क्वेश्चन ऐसा आ सकता है जो बाहर होता है, और दैट इज फाइन, वो क्वेश्चन होता है आपका स्ट्रेस टेस्ट करने के लिए, राइट, उससे थोड़ा सा स्ट्रेस टेस्ट हो जाता है आपके एग्जामिनेशन का, एंड दैट इज फाइन. So the correct choice here will be, guys, special resolution. Okay, so as per section 27, which relates to the variation of the terms of contract or object of prospectus, section 27 is the one which relates to the variation of the terms of contract or objects in the prospectus. If there is any kind of change in the term or purpose of the prospectus, it must be approved in the general meeting by way of special resolution. By way of special resolution, prospectus is a big thing. You can't take any chance with prospectus because it relates डायरेक्टली विद द पब्लिक मनी, राइट, यहाँ पे पब्लिक मनी इन्वॉल्व है, तो इसलिए आपको यहाँ पे सीधा स्पेशल रेजोल्यूशन पास करना पड़ता है, राइट. अच्छा, और कोई शेयर होल्डर नहीं खुश है आपके डिसीजन से, सो इन दैट केस में जो डिससैटिस्फाइड शेयर होल्डर्स है उनको आपको एग्जिट ऑफर भी देना पड़ता है. ओके, नेक्स्ट वन, अकॉर्डिंग टू द कंपनीज एक्ट, what is the time period within which an appeal filed before the appellate tribunal shall be dealt with and disposed of by it? Dissenting shareholders का मतलब होता है dissatisfied shareholders. वो satisfied ही नहीं है, फिर भी आप prospectus को लेके आगे बढ़े जा रहे हो, तो वो बोलेगा यार मेरा पैसा मेरे को वापस दे दो, उसके बाद तुमको जो करना है करते रहो prospectus में, ठीक है. Dissatisfied shareholders. Here the correct choice is option D, within 3 months from the date of presentation, right? So 3 महीने के अंदर यहाँ पे आपको रिजॉल्व कर दिया जाएगा, राइट. हाँ, पर अभी इनिशियली जब क्वेश्चन में कुछ नहीं बोला है तो फिर हमको 3 मंथ्स ही लिखना पड़ेगा, ठीक है, एक्सटेंशन की यहाँ कुछ बात करी नहीं है. सो दिस वाज द सेक्शन 422 वाज द सेक्शन, और यहाँ पे आपका डेफिनेटली एक्सटेंशन का भी टाइम लिमिट दे रखा था जो अब्दुल ने लिखा है 90 डेज का, राइट, नॉट एक्सीडिंग 90 डेज का, बट दैट एक्सटेंशन इज नॉट फॉर एनी सर्कमस्टेंस एंड यू नीड टू आल्सो रिकॉर्ड द रीजन फॉर दैट डिले एज वेल, राइट. नेक्स्ट वन, which of the following shall be considered as a security for the purpose of section 23 of this act? Unit linked insurance policy, actionable claims regarding the mortgage debt, securities issued by National Asset Reconstruction Limited. Now this can be a googly question, this can be directly a googly question, right. तो यहाँ पे मैं आपको बताना चाहूंगा सिर्फ ये दो ही सिक्योरिटीज के मीनिंग में आती है एज पर सेक्शन 2 सबसेक्शन H of the Securities Contract Act. Actionable claims related to the secured debt, security receipts by the reconstruction companies, they are also considered as securities. But ULIPs, unit linked insurance plan, unit linked insurance policies are not covered in the definition of security as of now. Okay, so this is a kind of googly question. एक क्वेश्चन ऐसा एग्जाम में आ सकता है, फेज 1 में भी आ सकता है, फेज 2 में भी आ सकता है. 2024 के अंदर ऐसा कोई क्वेश्चन फेज 1 के अंदर नहीं आया था. ओके, गूगली क्वेश्चन नहीं आया था फेज 1 के अंदर. 2024 का सेबी ग्रेड ए का पेपर थोड़ा सा स्ट्रेट आ गया था. ओके, सो ऐसा नहीं बोल रहा इस बार बहुत डिफिकल्ट आ जाएगा, बट जनरली ऐसा देखा गया है कि पीएफआरडीए के लेवल से थोड़ा सा मेरे को कम ही लगता है हमेशा सेबी का लेवल, राइट. काफी सारे स्टूडेंट्स का फीडबैक देखो और प्रीवियस ईयर क्वेश्चन पेपर स्टडी करो, तो गूगलीज जितनी पीएफआरडीए में आती है उतनी सेबी में नहीं आती है जनरली. ओके, a related party with respect to a company under the Companies Act means a director or is a relative, a public company in which the director or is a manager or is a director or holds holding along with the relative more than 2% of the paid up share capital, any person on whose advice, direction, or instruction a director or manager is accustomed to act. Yes, ऑप्शन डी. यहाँ पे सारे के सारे आ जाएंगे, यहाँ पे सारे के सारे आपके आ जाएंगे. The auditor appointed under section 139 of the Companies Act may be removed from his office before the expiry of his tenure only by way of special resolution of the company and what? Or just the special resolution is fine? Even if you have passed the special resolution, will it be fine? Or do you need something else as well? The correct choice is after obtaining the prior approval of the central government. After obtaining prior approval of the central government, right? Just give me a second. Only special resolution, bit confusing. Yeah, there should not be only in the option. There should not be only in the option. That's fine. Opportunity of being heard. Yes. Also, the opportunity of being heard needs to be given. The very first requirement of this particular section is first you need to give a special notice, right? You all are the shareholders, so you need to give the special notice. Then a board meeting will be conducted, right? Application to the central government will be made. You'll be getting approval from the central government. Then you need to, once you got the approval from the central government, you need to call an general meeting, right? You need to call an AGM and special notice will be sent on that AGM. At that AGM, the auditor will be given the reasonable opportunity of being heard, and on the same meeting, in the same meeting, you will be passing the special resolution, right? मीटिंग तो बाद में बुलाई ना. सबसे पहले तो क्या हुआ, स्पेशल नोटिस आया. सबसे पहले स्पेशल नोटिस आया तो पहले बोर्ड ऑफ डायरेक्टर साथ में हो गए सारे कि लेट्स टॉक अबाउट द सेम थिंग एंड लेट्स अप्लाई फॉर द सेंट्रल गवर्नमेंट अप्रूवल. देन वी रिसीव द CG अप्रूवल ऑल्सो. We called the AGM because as we have received the CG approval, now we have called the annual general meeting. Let's give the reasonable opportunity of being heard to the director and then pass a special resolution to remove that director. Okay, that's the usual procedure. Next one, which type of the share is issued by the company to its existing shareholders without receipt of any consideration from the shareholder for the issuance of such share? That's easy, right? It is nothing but my bonus issue. Bonus issue. Dash means a company not having any limit on the liability of its member under the Companies Act. This is also a very simple one. We say that the companies are limited liability companies. That's unlimited liability, right? That's unlimited liability. SEBI difficult level भी सेम होगा क्या? डिफिकल्टी लेवल भी सेम हो गया क्या? लाइक द क्वेश्चंस? यस अब्दुल, मोस्ट ऑफ द क्वेश्चंस ये सेबी के अंदर आ चुके हैं. मोस्ट ऑफ द क्वेश्चन सेबी के अंदर आ चुके हैं. प्रीवियस ईयर क्वेश्चन पेपर देखोगे आराम से सॉल्व होगा आप लोगों से पूरा कोर्स करने के बाद. सब्जेक्ट 2 की सबने पूरा कोर्स किया है, सारी क्लासेस देखी है, नोट्स पढ़े, एक आध मॉक टेस्ट भी दिया है, राइट? क्लासेस देख लिए, नोट्स पढ़ लिए, तो भी आप लोगों से प्रीवियस ईयर क्वेश्चन पेपर सॉल्व होगा, राइट? कॉमर्स एंड अकाउंट्स की बात करूं तो ऑलरेडी हमने हायर लेवल पे पढ़ी है. कॉस्टिंग हमने ऑलरेडी कुछ थोड़े ऊपर के लेवल पे पढ़ी हुई है. तो डेफिनेटली आपसे क्वेश्चंस होंगे प्रीवियस ईयर क्वेश्चन पेपर के, उसमें चैलेंज नहीं आएगा, है ना? प्रीवियस ईयर क्वेश्चन पेपर देखोगे, जो क्वेश्चंस आए हुए हैं इसी डिफिकल्टी लेवल के आते हैं. एंड वी आर कवरिंग दीज क्लासेस फॉर बोथ द पर्सपेक्टिव फॉर योर फेज 1 एज वेल एज फॉर योर फेज 2, है ना? तो जो अभी तक हमारे पास है उसको ही अच्छे से पढ़ना है, और नया कंटेंट अभी ऐड करने की नीड नहीं है अनटिल एंड अनलेस आपका पूरा कोर्स खत्म हो चुका है. ठीक है, सब लोगों के लिए बता रहा हूं. काफी सारे लोगों के मैसेज आते हैं कि सर और क्या पढ़ना है, और क्या पढ़ना है. भाई जो पढ़ा है उसको रीरीड करो, है ना? मैं खुद भी जब कोई नया प्रोविजन पढ़ता हूं ना, आज भी जब मैं कोई नया प्रोविजन पढ़ता हूं या अकाउंट्स में कुछ पढ़ता हूं, कॉस्टिंग में कुछ पढ़ता हूं, फाइनेंस में कुछ पढ़ता हूं, हर बार पढ़ने पे कुछ नया मिलता है, एक टेक्निकल चीज मिलती है हर बार, और इन चीजों पे ही क्वेश्चन बनता है. प्रीवियस ईयर क्वेश्चन पेपर खोल के देखोगे सब लोग, तो आप लोगों को लगेगा यार इसी टाइप के तो क्वेश्चंस आए हैं, राइट? बट व्हाट दे कैन डू इन द एग्जामिनेशन इज दे कैन जस्ट स्लाइटली ट्विस्ट द क्वेश्चन, एंड देन in that question you will be only able to attempt that once you have done the re-reading, re-revision, right? multiple times आपने revisions किए हैं तो ही वो चीज आप फिर उस टाइम पे सॉल्व कर पाओगे एग्जाम के अंदर, राइट? तो नोट्स को अच्छे से पढ़ो, अपनी क्लासेस के पीडीएफ को, क्लासेस को अच्छे से देख लो जिन लोगों ने क्लासेस नहीं देखी है. कॉन्सेप्ट वाइज स्ट्रांग हो जाओ. क्वांटिटी वाइज बहुत ज्यादा स्ट्रांग होने की जरूरत नहीं है कि सर मैं 10 तरीके की बुक सॉल्व कर लेता हूं, नहीं, वो रिक्वायर्ड नहीं है ना? वो रिक्वायर्ड नहीं है. बट वंस यू आर डन विद द कोर्स, ज्यादा से ज्यादा एमसीक्यू प्रैक्टिस करो, जो हम कर ही रहे, राइट? कोर्स खत्म होने के बाद ज्यादा से ज्यादा प्रीवियस ईयर क्वेश्चन पेपर सॉल्व कर लो, तो वहां आपको एज मिलेगा, डेफिनेटली आपको एज मिलेगा. और एक बार करने के बाद रुको मत, बार बार उसको पढ़ो. होता क्या ना, हम एक चैप्टर पढ़ते हैं, मान लो मैंने डिविडेंड, मैंने आपका प्रोस्पेक्टस वाला चैप्टर पढ़ लिया, डायरेक्टर वाला चैप्टर पढ़ लिया, फिर उसको छोड़ के कुछ और करने लग गया. दिन के 10-15 मिनट निकालो कि छोटे छोटे चैप्टर्स को रिविजन कर लो. अब जैसे कंपनी लॉ है तो वो एक ऐसी चीज है ना कि आप इसको कितनी बार भी रिवाइज कर सकते हो. हर चैप्टर को दिन में 10 मिनट दे दिए, 15 मिनट, 20 मिनट दे दिए, फटाफट से उसके नोट्स देख लिए, राइट? पीपीटीज रिव्यू कर ली, कोई प्रॉब्लम आ रही है लेक्चर में जाके देख लिया, कोई प्रॉब्लम आ रही है नोट्स खोल के देख लिया, अच्छा ये टाइम लिमिट भी है. सो इस तरह से आप 10-15-20 मिनट रोज दो ऐसे सब्जेक्ट्स को जो थ्योरेटिकल है पूरे. मैनेजमेंट हो गया, राइट? फाइनेंस हो गया. सो डेफिनेटली आपके इसमें वैल्यू ऐड करने वाले हैं यहाँ पे. ओके, अ पब्लिक कंपनी is a company which has a minimum paid up share capital of what amount? Minimum paid up share capital of what amount? I'm talking about the public company. So as of now, they haven't prescribed the amount of the minimum kind of amount for the public company. So as per section 2 subsection 71, public company means which is not a private company, right? Minimum amount as may be prescribed, and since there is no minimum prescribed amount, there should therefore as of now there is no such requirement. But these options make it contradictory, right? These options make it contradictory. तो यहाँ पे क्या होने वाला है आपका, इन दोनों में से मेरे को नहीं लगता है एज इट इज आने वाला है, मेरे को नहीं लगता है एज इट इज आने वाला है, राइट? सो यहाँ पे ज्यादा बेटर ऑप्शन मेरे हिसाब से एज में भी प्रेस्क्राइब्ड हो जाएगा, एज में भी प्रेस्क्राइब्ड हो जाएगा। फॉर कंक्लूजन पार्ट वी कैन से कि नहीं भी होगी कैपिटल तो चलेगा, बट एज में भी प्रेस्क्राइब्ड यहाँ पे बेटर आंसर हो जाएगा। बट दिस इज अ आई विल से फॉल्टी क्वेश्चन हियर, सो बेटर है कि यहाँ पे हम एक ही ऑप्शन रखें, राइट? बेटर है कि हम यहाँ पे एक ही ऑप्शन रखें, राइट? So guys, here is the first question. What is the maximum age limit for the chairperson in the National Company Law Appellate Tribunal as per the guidelines of the Companies Act? What do you think is the maximum age limit for the chairperson of the NCLAT? Here we are talking about the maximum age of the NCLAT. Chairperson, right? That to chairperson. That is 70 years of age, right? That is 70 years of age. Perfect. Next one is, which of the following statement are correct relating to the nature of the shares or debenture of the company? Relating to the nature of the shares or debenture of the company. That's both option A and B, right? Movable property plus freely transfer. The shares of the companies are movable property and they are actually freely transferable also, right? They are also freely transferable also. The certificate of the shares issued by the company should be signed by two directors or a company secretary, issued under the common seal if any, signed by two directors or by a director and a company secretary wherever the company has appointed a CS, either A or B or either B or C. The correct answer, guys, here will be B or C, okay? B or C. The correct answer will be B or C. It is definitely issued under the common seal, if any, of the company, and it is signed by two directors and one director and one company secretary. One director and one company secretary. अभी ठीक है? So seal तो required है. Seal तो required है. As per section 46, it mandates that the share certificate must be issued by the company's common seal or it is signed by two directors or a director or a company secretary wherever they are appointed. But the problem is they have used the word or in between, right? They have used the word or in between in the language of law itself. So that's why we have taken either B or C, either B or C. Next one. A person aggrieved by any order of the tribunal may prefer an appeal to whom? अच्छा, वैसे सील होती है, ठीक है, वैसे सील होती है कंपनी के शेयर सर्टिफिकेट पे. Any person aggrieved by an order of the tribunal may prefer an appeal to what? That's very easy, right? National Company Law Appellate Tribunal. So we have seen that NCLT के order से जो अग्रीव्ड पार्टी है वो कहां पे अपील करते हैं? एनसीएलएटी के अंदर करते हैं. व्हाट अबाउट द फर्दर अपील? व्हाट अबाउट द फर्दर अपील गाइस? What about the further appeal? High Court or Supreme Court? Supreme Court है ना? Not High Court, directly Supreme Court. Perfect. A company shall not capitalize its profits or reserve for the purpose of issuing fully paid up bonus shares unless authorized by MOA, partly paid up shares on the recommendation of the board authorized in the general meeting, both B and C, all A, B and C. Now option B is regarding partly paid up shares, which if any, until you make it fully paid up. The correct choice here will be option D, both B and C, right? Partly paid up shares. First, you need to make the partly paid up shares as fully paid up shares before making any corporate action here, and on the recommendation of the board authorized in the general meeting of the company. So both B and C are correct here, right? Both B and C are correct here. Option D will be the correct choice. Perfect. The first board meeting of the company should be held within dash as per the Companies Act. A very direct question, a very simple one, right? A very direct question. The first board meeting of the company. The first board meeting of the company should be held within how many days as per the Companies Act? So first we need to incorporate the company, right? And after incorporation, from the date of incorporation, within how many days? Within how many days? Yes, within 30 days from the date of incorporation, we need to conduct that first board meeting. This is as per section 173, right, which is related to the meetings of the board. Every company shall hold the first board meeting within 30 days of the date of incorporation, and thereafter, that company needs to have minimum 4 meetings of its board of the directors. अच्छा, गैप कितना नहीं होना चाहिए? 2 मीटिंग्स के अंदर गैप कितना होना चाहिए मैक्सिमम? कितने गैप से ज्यादा नहीं होना चाहिए? एनी आइडिया अबाउट दैट? व्हाट शुड बी द गैप? यस, वेरी गुड. 120 days का गैप, राइट? Not more than 120 days shall intervene between two consecutive board meetings. So जो मीटिंग के अंदर गैप दे रहे हो आप, this gap should not be more than 120 days. This gap should not be more than 120 days. Perfect. Next one. Under section 54 of the company, which is related to the sweat equity shares, what is the lock-in period for sweat equity shares? For sweat equity shares. That's 3 years, right? That is 3 years. A listed company may appoint one director as a dash shareholders director. Executive, majority, small, non-executive, or independent. That is small shareholder, right? A listed company may appoint one director as a small shareholder. So option C here is the correct choice. Option C here is the correct choice. Next one. The special resolution authorizing the issue of sweat equity shares shall be valid for making the allotment within a period of how much duration? Within a period of how many days? The special resolution authorizing the issue of sweat equity shares shall be valid. Let's suppose if we have passed a resolution for the issuance of the sweat equity shares, then it will be valid for how many days? Carefully read the options and let me know which is the correct one here. Yes, not more than 12 months from the date of passing the special resolution. So once we have passed the special resolution within 12 months, you need to complete that, right? That is for the sweat equity shares. Next one. Modern Furniture decided to raise capital by issue for which prospectus need to be issued. The copy of the prospectus submitted with the registrar for filing need to be duly signed by whom? The prospectus copy that you are submitting to the registrar need to be duly signed by whom? Any two directors including MD, majority of the directors including proposed directors, every director or proposed director. Every director or every proposed director. Is it majority or every director? Yes. It is every director or proposed to be appointed director as per section 26, right? As per section 26. Next one. Dash capital means such part of capital which is for the time being subscribed by the members of the company. It's a very simple one. Dash means such part of capital which is for the time being subscribed by the members of the company, paid up capital, approved capital, allocated capital, subscribed capital or subscription capital. A very simple one, a very direct question. Based on a terminology. The correct answer here will be subscribe capital, right? Option D, subscribe capital. So it's nothing but a portion of my capital that members have actually agreed to take up and pay for. So we have discussed earlier regarding the different types of capital, like we have authorized share capital, right? We have authorized share capital, we have subscribed capital, we have called up capital. Then out of that, we have paid up capital and so on. Next one. The issue of shares by the company on a discount is prohibited and thus it shall be what? Thus we can state that it shall be what in the eyes of law? Void, illegal, voidable, unenforceable or unauthorized. it is void. It is void, right? It is completely void. Why? Because it is prohibited in the Companies Act 2013, except some cases. Except some cases, it is prohibited. So I can't issue shares at a discount, and it is void. It is not voidable at the option of the aggrieved party. So we can't claim, like, let's suppose a company is issuing the shares on discount. I came to know that the company is issuing shares at a discount. So I was quite excited and I applied for the shares. No. So I can sue the company later on. No. Because the contract is void in itself. I should have that knowledge that issuing the shares at a discount is prohibited in Companies Act 2013. It will become void. This contract this contract will become void only. Okay. So we have seen section 53. Companies Act strictly prohibit companies to issue the shares at a discounted price. Right? And there are some exceptions as well, which we have earlier discussed. The members of the tribunal and the technical members of the appellate tribunal shall be appointed on the recommendation of which entity? The correct answer here will be yes, selection committee, right? So as per section 412, we have discussed this thing that the selection committee will be recommending the appointment. The notice of the meeting at which the special resolution is proposed to be passed authorizing the buyback shall be accompanied by an explanatory statement stating what? Amount to be invested, time limit for completion, disclosure of all the material facts, class of securities to be purchased, or all of the above. Or all of the above. Yes. The correct answer here will be all of the above only. सर who appoints the judicial members? देखो वो भी सिलेक्शन कमेटी करती है ना, वो भी सिलेक्शन कमेटी करती है, वहां पे भी मेंबर्स रिलेटेड अपॉइंटमेंट सिलेक्शन कमेटी करती है. According to section 409 of the Companies Act, a person shall not be qualified for appointment as a judicial member unless he is or has been a judge of High Court for 5 years, unless he is or has been a district judge for at least 5 years, he has or at least 10 years been an advocate of a court, all of the above or both B and C. Here we are talking about the judicial member. We are talking here about the judicial member. He is or has been a district judge for at least 5 years or has been an advocate for at least 10 years. Option E. Only these two requirements are there. The quorum of the meeting of the board of directors of a company shall laid down under the Companies Act shall be how much? How much is the bare minimum quorum we need for the board meeting? That's 1/3 of the total strength or 2 directors, whichever is higher, right? 1/3 of the total strength or 2 directors, whichever is higher. That should be the quorum of the board meeting, right? That should be the quorum of my board meeting. Next one. Where the debentures are issued by the company shall create a debenture reserve, the debenture redemption reserve account out of the profits of the company available for payment of dividend. Amount created may be utilized by the company for such use as the board of director may decide. Amount created shall not be utilized except for the redemption of debentures, both A and B, both A and C. In the last question related to High Court judge, there was no requirement of 5 years. Okay, if you are a High Court judge, Vaishali, then you can become a become a judicial member, right? So if you want to become a judicial member, you need to be a High Court judge. You need to be a district court judge for at least 5 years or more, or advocate for 10 years or more. So there is no such bare minimum limit of number of years in being a judicial member, right? Yes. Here the correct answer will be both A and C. So if you are creating a DRR, if you are creating a debenture redemption reserve account, if you are creating a debenture redemption reserve account, then in that case, it should be out of the profits of the company. And if you have created, then you need to use it only for the purpose of the redemption of debentures and not for any other purpose, right? So what usually happens is, let's suppose I have a debenture obligation. After 10 years, I have to pay 10 lakh rupees to the debenture holders. Now, will I be sparing that money in the last year itself? No. I'll slowly try to create a reserve, which is nothing but debenture redemption reserve account. Why? Because at the end of the 10th year, I need to accumulate 10 lakh rupees, and that's how we start accumulating this reserve. National Company Law Tribunal under the Companies Act is constituted by which entity under the Companies Act? Yes, that is the central government. That is the central government. So, as per section 408, it clearly specifies in the very first line itself that the central government establishes the NCLT with the judicials and the technical members as may be required, right? So, it's central government. It is central government. Next one, what requirement does section 141 of the Companies Act impose on the firm appointed as auditor of the company regarding the authorization to act and sign on behalf of the firm? So, Sumesh, if we talk about the NCLT, right? NCLT as a body is one, but there are so many benches, right? There are so many benches of NCLT located at different regions, right? So, each bench has a territorial restriction over the specific state or union territory. But as a body, it is only one. So, yes, option B here, a chartered accountant, only the partners who are CA, they can act and sign on behalf of the firms, right? And that chartered accountant should be in practice. It should be a practicing chartered accountant. Next one, no company shall issue a prospectus or make any offer or invitation to the public or to its member dash for the subscription of its debentures unless the company has before such issue or offer appointed one or more debenture trustee. This is going to be an important question. We have understood, we have done the concept of debenture trustee in the circular class also, right? We have discussed the concept of debenture trustee, right, in the circular class. So the answer is exceeding 500. Okay, exceeding 500 is the correct choice as per section 71. which mandates that when offering debentures to more than 500 persons, a company needs to appoint one or more debenture trustee before the issuance. What is the concept of debenture trustee? Debenture trustee will be taking care of the collateral, right, in case of secured debentures, and he'll be taking care of your rights and obligations, right? No company limited by shares after the commencement of this act issue preference shares, which are what? Here we are talking about the preference shares, right? Here we are talking about the preference shares, which are irredeemable, right? That is straight, which are irredeemable. A very simple one. Can you guys tell me some of the exceptions? Can you guys tell me some of the exceptions and tell me the maximum number of years for which I can issue the debentures, redeemable debentures? Also tell me the exception of that limit. Twenty years the timeline, yes. And for infrastructure projects, 30 years the timeline, right? 30 years is the timeline, but we need to start making the payment. Perfect, Nidhi. We have to start making the payment from the 21st year. So every year we have to pay at least 10%. So I can say every year if you are paying 10%, then after 10 years you are paying 100% of the amount, right? So it will be option B, irredeemable. And I'm glad you guys know the exceptions. Perfect. Next one. Which official act as the convener of the selection committee? Yes, the correct choice here is Secretary of the MCA, Ministry of Corporate Affairs. This is as per section 412. Next one, which of the following statement regarding the reduction of the share capital by a company limited by shares or by guarantee is true? A company can reduce its share capital without any kind of approval. Reduction of share capital can only be done by an ordinary resolution. Share capital reduction can only be initiated by the shareholders. Share capital reduction must be approved by ROC. The reduction of the share capital requires confirmation of the tribunal. Which one will be the correct statement is true regarding the reduction of share capital? And the guy's correct choice here is option E only. The reduction of the share capital requires confirmation from the tribunal. When I say tribunal, it's nothing but NCLT only, right? Upon application by the company and it requires a special resolution as well. So option E is the correct choice here. Can you also tell me the composition of the audit committee? What is the composition of the audit committee? That's the minimum number of 3 directors. An independent director need to form a majority in that. Option D is the correct, and this is as per section 177, right? 177 can be an important section for the examination as well. As laid down under the Companies Act, every company shall hold first meeting of the board of directors within 30 days of the date of the incorporation, and thereafter hold a dash meeting of the board of directors every year. This is again a simple one only, and a related question we have done initially in today's class. Minimum 4, yes. Minimum 4. Minimum number of 4 meetings. Right? Minimum number of 4 meetings is required here. So option C. Next one. According to the Companies Act, what action is required of a company after its buyback, after the company is done with the buyback of its own share or specified security? Now, rare chances, because this is a very old provision that after the buyback you need to physically destroy the securities. Nowadays we don't have any kind of physical securities, so that's why which makes this provision a bit, I will say, irrelevant in these days, because there is no physical destruction. All the securities nowadays are in dematerialized form, right? So no company shall appoint or reappoint any person as its managing director, whole-time director or manager for how much tenure? For a term exceeding 5 years at a time. For a term exceeding 5 years at a time. No company shall appoint or reappoint any person as its managing director, whole-time director for a term exceeding 5 years at a time, right? Which of the following statement regarding the dividend is correct? Dividends are only paid annually to the shareholders. Dividend payments are made by the company to its creditors. Dividend includes interim dividend declared by the company. Dividend payments made by the shareholders to a company. None of the above. Option C. Option C here will be the correct choice. Dash may have one director elected by the small shareholders. So I think we have discussed this particular question. Which company may have one director elected by small shareholders in such manner and with such terms and conditions as may be prescribed. As may be prescribed. Small company, listed company, unlisted company, private company, OPC. Do you really think, guys, it is? The answer is a small company. Yes, the correct answer here will be listed company, right? Listed company. So small देख के फटाफट से small को टिक मत कर देना जल्दी जल्दी में. The correct answer here will be listed company, right? As per section 151. Next one, dash may fix the remuneration of the first auditor appointed by the board as per section 142 of the Companies Act. Who will be fixing the remuneration of the first auditor? That's an easy one again. The board of directors are going to decide the remuneration. So एक memory technique बताई थी, जो भी appoint करता है वही उसका remuneration decide करता है, right? जो भी appoint करता है वही उसका remuneration decide करता है. तो in case of first auditor, the board of directors have appointed it, right? The auditor was appointed by the board of directors, so they will be fixing the remuneration. In case of subsequent auditor, it was appointed at the time of general meeting, right? At the time of annual general meeting, he or she was appointed at the time of annual general meeting. So the remuneration will also be decided in the annual general meeting itself. Next one. Who is responsible for auditing the accounts of Investor Education and Protection Fund? CAG, right? Comptroller and Auditor General of India, CAG, as per section 125, states that the accounts of the Investor Education and Protection Fund will be audited by the Comptroller and the Auditor General of India, CAG. Perfect. Next one, the central government shall, from the receipt of the application under section 153, allot a director identification number to an applicant within how many days? Within how many days? Within 1 month, right? Within 1 month. So option C here will be the correct choice. Next one, dash capital means capital as authorized by the memorandum of the company to be the maximum amount of share capital of the company. Maximum amount of share capital of the company. Nominal, issued, subscribed, called up. Or either B or C. Maximum issued. Maximum. The maximum amount that I can issue is nothing but my nominal capital, right? Nominal capital, which is also called as my authorized capital. So let's suppose I have the authority to issue 1 lakh shares at the rate 10. 10 is my face value. For example, I have issued only 80,000 shares. So how much is my maximum capital? Maximum I can go up to 1 lakh. Maximum I can go up to 1 lakh. Then out of that, I have decided to issue only 80,000 share capital. Out of that, public only subscribed to 60,000 shares. Now how much I have called up? How much I have called up? will be the called up capital. Say for example, on 60,000 I have just called up 6 rupees as of now, and you guys have paid me only 4 rupees as of now. So that will be my paid up capital. In the balance sheet, always we show the paid up capital only. Rest of the details we always show in the notes to accounts. पेड अप एंड ऑथराइज कैपिटल में क्या डिफरेंस होता है? देखो बहुत बड़ा डिफरेंस होता है. आई होप यहां पे समझ में आया होगा क्या डिफरेंस होता है. ऑथराइज शेयर कैपिटल का मतलब होता है इतनी मेरी अथॉरिटी है, उससे ज्यादा तो मेरी अथॉरिटी नहीं है. सो मैक्सिमम आई कैन इशू 1 लाख शेयर्स. अब जरूरी तो नहीं है कि जो मैक्सिमम मैं पूरा का पूरा इशू कर दूंगा, राइट? सो मैंने थोड़ा सा इशू किया, 80,000 शेयर्स इशू किया. फिर लोगों ने सब्सक्राइब 60,000 शेयर्स ही किया. उसमें से भी मैंने सिर्फ 6 रुपए मांगे, पर लोगों ने सिर्फ अभी तक 4 रुपए ही दिए. So that will be the paid up capital. Paid up capital means how much money you have actually received as of now from the shareholders, right? In the balance sheet we only show paid up capital. Acha, what do you mean by reserve capital? Can anyone tell me what is the meaning of reserve capital? What is the meaning of this reserve capital? We have discussed this concept, difference between reserve capital and capital reserve. Yes, reserve capital is called at the time of winding up of the company. No, subscribed capital and called up capital may differ because my subscribed capital is 60,000 into 10, but I have just asked as of now just 6 rupees, right? I'm just calling 6 rupees, so that will be my called up capital. How much I'm calling? I'm just calling 6 rupees out of 10. So there can be difference. Yes, reserve capital means I have actually reserved that capital and I'll use it. I'll call that only at the time of winding up. Perfect. Then guys, tell me this one. As per the definition of the prospectus under the Companies Act, a prospectus means and includes what? Shelf, red herring, any document described or issued as prospectus, all of the above, or both A and B, or both A and B. It will be all of the above. Why? Because any document is deemed prospectus when we issue it, right? Which we use it for the public issue, it comes under the concept of deemed prospectus, right? Next one, the maximum number of public companies in which a person can be appointed as a director. I'm not asking about the maximum number of directors, right? I'm asking about the fact that in how many companies a director can be appointed as a director. Maximum number of public companies in which a single person can be appointed as a director. Not exceeding 10, right? Not exceeding 10. In total, you can be a director in 20 companies, but if I talk about public companies, the directorship cannot exceed 10. The directorship cannot exceed 10, right? What happens if no auditor is appointed or reappointed at any annual general meeting? What happens when no auditor is appointed or reappointed at any annual general meeting? So we have annual general meeting to appoint the auditors, but let's suppose in this particular annual general meeting, no auditor is appointed or reappointed, then what will happen in that case? What's going to happen in that case? Now in that case, the existing auditor continues to serve the auditor of the company, right? The existing auditor will continue to be the auditor of the company until we appoint a new auditor, right? So option C is the correct choice. Option C is the correct choice. Next one. Under the Companies Act, which is the notice, what is the notice period for the purpose of calling a board meeting? Let's suppose I want to call a board meeting. Now, what will be the notice period if I want to call a board meeting, which should be sent in writing to every director at its registered office with the company? So how many bare minimum days notice I have to give for calling a board meeting? The correct answer here is not less than 7 days, right? This is as per section 173. This is as per section 173. We have discussed it earlier also. Not less than 7 days for calling a board meeting. Here we have studied this. The Act requires that not less than 7 days notice in writing to be given to every director at the registered office by hand, by delivery, or by electronic means, right? Shorter notice is also permitted, but at least one independent director shall be present at the meeting, right? So, but the bare minimum day is 7 days. If you want to give a shorter notice, provision related to that is also there in the law. But as of now, the answer is going to be 7 days, right? The answer is going to be 7 days here. Next one. Can you tell me the tenure of the independent director is for how many consecutive years, after which a special resolution is required for the reappointment purpose? After that, a special notice is required for the reappointment purpose. Here we are talking about the tenure of the independent directors. The correct choice here is 5 years, right? The correct choice here is 5 years, option A. Option A here is the correct choice. So the tenure of the independent director will be 5 consecutive years, and after that you can reappoint him. Yes, you can reappoint independent director for a second term as well, but a special resolution will be required for that, right? A special resolution will be required for that. Next one, the provision relating to the loan to the director, etc., under the Companies Act shall not apply to which case? Case number 1, giving any loan to a managing or a whole-time director pursuant to any scheme approved by the members by an ordinary resolution. Option B, any loan made by a holding company to its wholly owned subsidiary company, or any guarantee or security provided by a holding company for its wholly owned subsidiary company. Option C, a company in which the ordinary course of its business. In the ordinary course, the company is providing loans and guarantees or securities for the repayment of the loan, right? So that's the part and parcel activity of the company. Option D, both A and C. Option E, both B and C. Take your time and let me know in the comment section what's the correct answer here. You guys can take your time, आराम से क्वेश्चन को पढ़ सकते हो, लाइंस को पढ़ सकते हो, and then let me know which one is the correct. Option E, option E, option E. Okay. Why not A? A सही नहीं है. A is not correct regarding the loan to the directors. I can also give loans in advance to managing director or whole-time director, right? Pursuant to the scheme. Let's suppose we have a scheme where we give loans and advances to the employees. Then why not A? Then why not A? Why not A? What specific conditions? Because A point was also there in the exceptions. You can give loans to the managing director or the whole-time director in pursuant to any scheme approved by members. But why A is not the correct choice? Definitely the correct answer is going to be option E, both B and C. But why A is not the correct choice? MD whole-time director को दे सकते हो. Yes, special resolution is required for that. Special resolution is required for that, not the ordinary resolution. Next one. What is the definition of qualified institutional buyer as per the Companies Act 2013? Here the correct choice will be a buyer meeting the criteria specified in the SEBI 1992. So the qualified institutional buyer is defined under the SEBI's regulation in section 42. It is defined. Okay, in section 42 it is defined. Which of the following statement regarding the appointment of director in a company is accurate? So you have to figure out the accurate statement here. You have to figure out the accurate statement here. They have given you 5 statements. You need to check for the accuracy, and this is regarding the appointment of directors. This is regarding the appointment of directors. We have done a similar question like this, right? I think yesterday only. We have done a similar kind of question like this in 2 parts. And the correct choice will be option C. A company can appoint more than 15 directors, but only after passing a special resolution, right? Only after passing a special resolution, a company can appoint more than 15 directors. Next one. When an application for transfer of partly paid up shares is made by transferor alone, let's suppose I am a transferor, that means I am transferring my shares to someone else, maybe to Mr. B, who is a transferee, right? The transfer will not be registered unless the company notifies to the transferee, and transferee gives a no objection certificate within how many days of receiving the notice. Say for example, let's suppose I have transferred some shares to Nancy. So I am the transferor, Nancy is the transferee, right? Now, what will happen? The company will notify Nancy that these are partly paid up shares, right? These are partly paid up shares, and Nancy has to give a no objection certificate within how many days of the notice? Within how many days of the notice this can be effected? Apologies, I was on mute. Sorry. The correct answer here will be 2 weeks, right? So Nancy now has to communicate that Nancy is having no objection, right? Then only this will be affected, right? Then only this is going to be placed by the company until and unless the company will put the request on hold till the time the transferee gives a no objection certificate, right? Sir, ICDR 2009 in that question, let me recheck which question. This one, qualified institutional buyer. Investor meeting criteria specified under ICDR. Okay, so this will be more specific. This will be more specific, right? Option D will be more specific. That's correct, right? In that case, option D will prevail over E. Okay, apologies, I missed that option D. I'll make it definitely correct. Okay. In the final PPT, I'll definitely make that correction. The function performed by the National Financial Reporting Authority. We do have NFRA, right? So what are the functions of NFRA? What are the functions of NFRA? What are the functions of NFRA? That's correct. All of the above are functions actually of NFRA, right? National Financial Reporting Authority. Acha, this one we have discussed in the paid classes also, which is the section related to the cost accounting records, audit of the cost accounting records in the Companies Act 2013. So this is somewhere related to your costing basics also. This is related to specifically your Companies Act also. So which section relates to the audit of the audit of the cost accounting records in your Companies Act? A very simple one, right? 2 times this question came in regulatory body examination. That's section 148. Perfect. Section 148 deals with the audit of the cost accounting records. Next one, as per section 139, how are appointments, including filing a casual vacancy of an auditor, made when a company is required to constitute an audit committee under section 177? So we are constituting an audit committee under section 177. We all know that audit committee ka section is 177. So we have to constitute an audit committee under this section. Now, how the appointments, including filing of casual vacancy of the auditor, will be made? The correct answer here will be appointments will be made after taking into account the recommendations of the audit committee. If directly the BOD will be appointing, then it makes no sense. Why? Because they do have an audit committee under section 177. So let the expert do the work of appointment of the audit committee. So definitely the recommendations will be considered of the audit committee, and if the board may decide to not to reconsider the recommendation, we have discussed that they will again refer back to the audit committee, and the audit committee will again start recommending the new names. So option E here will be the correct choice. Next one, what are the various conditions on the basis of which a retiring auditor may be reappointed at an annual general meeting as per the Companies Act? A retiring auditor may be reappointed. A very simple one. You can easily eliminate the options here. This question also came in a regulatory body exam. Retiring auditor may be reappointed. May be reappointed. If he is not qualified for reappointment, then how you can appoint it? How you can reappoint it? right? So usually we feel that the option will be all of the above, but it is not. It is not here. Why? All the options are negatively drafted. So in the option A itself, I can say that he is not qualified for reappointment. If he is not qualified for reappointment, then how we can reappoint him? So option A पढ़ते ही मेरा E तो eliminate हो जाना चाहिए, A भी eliminate हो जाना चाहिए, right? Yes. Option B here will be the correct choice. अब ये इस टाइप के क्वेश्चंस क्या बहुत सिंपल होते हैं, पर जल्दी जल्दी में हम ई टिक कर देते हैं, राइट? मे बी क्वेश्चन के अंदर देयर वाज नॉट अ नेगेटिव फ्रेमिंग की टेल मी व्हेन वी कैन नॉट अपॉइंट द रीअपॉइंटिंग ऑडिटर, और हम पढ़ते हैं पहला आंसर ये निकलता है, फिर एक दो ऑप्शन और पढ़ते हैं तो लगता है ये तो नेगेटिव क्वेश्चन है, सीधा ई टिक कर देते हैं, राइट? पर they have clearly mentioned in the question then how the retiring auditor can be reappointed. So we can reappoint him if he has not given any company a notice in writing regarding the unwillingness to be reappointed, right? So that means he is willing to get appointed and he is not disqualified as well, so definitely we can reappoint him. Next one, as per the Companies Act, the securities premium account cannot be used for what purpose? I can't use securities premium for what purpose here? So this is from the section where we have discussed about the purposes for which securities premium account can be used. The correct answer here will be option A, and this is one of the most important question. Section 52 related to the application of premium received on issue of shares. So if I have securities premium, there are only limited purpose, right, where I can actually use securities premium account, We have discussed this concept in section 52, right? Acha, this one we have covered it in the paid class as well. What if I'm not complying with section 52, I'm using securities premium account for some other purpose as well? This is also very, very important. I'm using securities premium for some other purpose. I'm not utilizing securities premium for exactly the same purpose. What will happen in that case? Same thing we have discussed in the paid class as well. Exactly the same question. Yes, it will be treated as a capital reduction, right? It will be treated as a capital reduction here. If I use it for any other purpose, we will assume that it is a capital reduction. Next one, the president of the tribunal and the chairperson and judicial members of the appellate tribunal shall be appointed after consultation with whom? CGI, President of India, Vice President of India, Chief Justice of High Court, Prime Minister of India. Now two options are very, very vague in this. देखो पीएम और प्रेसिडेंट के पास और कुछ काम तो है नहीं, वाइस प्रेसिडेंट के पास भी और कुछ काम तो नहीं है कि वो ये सारे काम करेंगे, उनके पास और भी इंपॉर्टेंट काम है, राइट? सो द कंफ्यूजन कैन बी देयर इन ऑप्शन ए एंड ऑप्शन डी. अदरवाइज तीन ऑप्शंस तो यहाँ पे सीधे एलिमिनेट हो रहे हैं, राइट? ये भी एग्जाम में आया हुआ क्वेश्चन है. यस, चीफ जस्टिस ऑफ इंडिया एंड नॉट हाई कोर्ट, राइट? नेक्स्ट वन, which section of the Companies Act lays down provisions relating to a document containing offer of securities for the sale to be deemed prospectus. So which is the section of deemed prospectus here? Section for deemed prospectus, it is section 25, right? Section 25 relates to the deemed prospectus. Next one. It is the charter of a company, a document that defines the area within which a company can operate. The first step in forming a company is to prepare this document. It is known as Articles of Association, Letter of Formation, Letter of Incorporation. No such single document is there. Maybe it's in combination of multiple documents or Memorandum of Association. Now confusion can be there in MOA or AOA, right? MOA or AOA, but they have clearly written in the very first line, this is the charter of the company, and we always call that as MOA, right? As MOA, it is the foundational document, it is the foundational charter of the company, which outlines what are the objectives of the company, the power and the scope of operations, right? AOA is more related to the internal rules and regulations related to company, and MOA will be a primary document, which is the charter of the company, defining the area in which the company can operate, the objectives and the power and scope of the operations, right? Acha, which of the following is true regarding a red herring prospectus? It is issued prior to the issue of a prospectus. It shall carry the same obligation as are applicable to the prospectus. It shall be filed with the registrar at least 3 days prior to the opening of the subscription list in the offer. All of the above, both A and C. क्वेश्चन नंबर, ठीक है यार, क्वेश्चन नंबर भी दे देंगे, ठीक है, क्वेश्चन नंबर भी दे देंगे. कोई क्वेरी हो तो आप मुझे सीधा स्क्रीनशॉट लेके भी सेंड कर सकते हो, तो दैट विल आल्सो बी फाइन. नंबर देना होगा तो मैं नंबरिंग भी कर दूंगा, कोई इशू नहीं है उसमें. यहां पे करेक्ट आंसर आपका हो जाएगा ऑल ऑफ द अबव. ओके, ऑल ऑफ द अबव विल बी द करेक्ट चॉइस हियर. ए बी सी तीनों ही यहां पे आपके करेक्ट हैं. इट इज इशूड प्रायर टू द इशू ऑफ फुल प्रोस्पेक्टस. पहले आप रेड हियरिंग प्रोस्पेक्टस इशू करते हो, राइट? उसके बाद इट शैल कैरी द सेम ऑब्लिगेशंस एज एप्लीकेबल टू द प्रोस्पेक्टस, राइट? उसके बाद इट शैल बी फाइल्ड विद द रजिस्ट्रार एटलीस्ट 3 days prior to the opening of the offer. Option D here will be the correct choice. Okay, option D here will be the correct choice. Next one. The audit committee of a company must consist of at least how many directors, with independent directors forming a majority? With independent directors forming a majority. The correct choice here will be 3, right? Minimum 3 directors are required, with the independent directors forming a majority here. So option A here is the correct choice, right? What is the time period within which the amount of the dividend, including the interim dividend, shall be deposited in a scheduled bank in a separate account from the date of declaration? So the moment I declare the dividend, I have to deposit that in a scheduled bank. What is the time period for that? that is 5 days, right? This is in accordance with section 123 related to the declaration of the dividend. A very simple one, a direct question. Next one, notice relating to the appointment of an auditor shall be filed with the registrar within how many days of the meeting in which the auditor is appointed. Let's suppose you have appointed the auditor. Now, within how many days you need to send that notice to the registrar? Yes, the correct choice here is 15 days, right? So as per section 139, you need to inform the registrar regarding the appointment of the auditor, that too within 15 days. Next one, any change in the name of the person indicated in the memorandum of one person company as a nominee shall be what? May be deemed to be an alteration of memorandum, shall be deemed to be an alteration of memorandum, shall not be deemed to be an alteration of the memorandum, may not be deemed to be an alteration of the memorandum, is deemed to be an alteration of the memorandum. Now you have changed the name of the person indicated in the memorandum of OPC. Here it shall not be deemed to be an alteration of the memorandum. This is as per section 3. Okay, this is as per section 3. So it is, I will say, deep from the provision. So one question definitely we all can expect will be of such a kind that you will face difficulty in understanding in the examination also, and that is fine, right? That is more related to your stress test than your studies test. The central government shall from the receipt of the application under section 153 allot a director identification number, a DIN number, to an applicant in such manner as may be prescribed. Within how many days the central government from the receipt of application under section 153 allot a director identification number? That is within 1 month, right? Within 1 month. Which term describes the dividend declared by XYZ Limited at its annual general meeting for the financial year 2025? Let's suppose, for example, the dividend is set at 10%, and this dividend is declared in the annual general meeting. In the annual general meeting. Now, what kind of dividend we can call this? Interim, final, preferential, general dividend, or none of the above? That's a easy one, right? It will be a final dividend. It will be a final dividend. When I declare a dividend between two annual general meetings, then that is called as an interim dividend. Here it will be called as a final dividend because I am declaring that in the annual general meeting. Next one, the articles of the company may confer on its board of directors the power to appoint any person other than someone who failed to be appointed as a director in the general meeting as an additional director at any time, who shall hold office for what period of the tenure. So this is regarding the tenure of the additional director, right? This is regarding a question on the tenure of additional director. One of the most repeated kind of the questions are related to the days limit and related to the tenure limit of directors, right? So these topics should be in your strong zone. They are definitely going to ask you a lot of numbers in the examination. The correct choice will be A or B, whichever is earlier, right? A or B, whichever is earlier, yes. Up to the date of the next annual general meeting or till the last date on which the annual general meeting should have been held, right? So on the next annual general meeting, or the date on which the annual general meeting was planned, whichever is earlier. So this is decided on a conservative basis. That's why we have mentioned whichever is earlier here from both the dates. According to section 175 of the Companies Act, where dash of the total number of directors of the company for the time being required that any resolution under circulation must be decided at the meeting and not by circulation. The chairman shall put the resolution to be decided at a meeting rather than resolution by circulation. Not less than 1/3, right? Not less than 1/3. So if not less than 1/3 total number of directors are asking the company to put that resolution in a meeting rather than just passing it via circulation, so the chairman needs to decide that resolution only at the meeting and not by circulation. Next one, on application made to by the company, a company limited by shares or limited by guarantee and having share capital, may by special resolution reduce the share capital. If a company wants to reduce the share capital, do we need to take permission of the NCLAT, Tribunal, central government, appropriate authority, or registrar of companies? What do you think? And one of the most common mistake students do in this particular question, I'll tell you, they take option A. They take option A because they are in so hurry, for obvious reasons, because in an exam oriented mahol it becomes difficult to focus, and that's why they read it as NCLT instead of NCLAT. This is the Appellate Tribunal. We go to the Appellate Tribunal only when we have some problem with the NCLT's decision. Here in the case, Tribunal is the correct answer, which is NCLT. But काफी सारे स्टूडेंट्स, ये वाला क्वेश्चन आया था और काफी सारे स्टूडेंट्स ए को टिक करके आ गए थे रादर देन बी, क्योंकि वहां पे एनसीएलटी दिखा, एनसीएल ए तो दिखा ही नहीं एग्जाम में. ऐसा होता है कितनी बार. ठीक है, अभी तो क्लास चल रही है, सब थोड़ा सा रिलैक्स मोड में हो, बट एक्चुअल में जब एग्जाम में होगे तो वहां पे ए नहीं दिखता कितनी बार. ठीक है, या कुछ कुछ चीजें नहीं दिखती कितनी बार. तो एकदम कामली पेपर को डील करना, ऐसा नहीं कि हमको बहुत जल्दी जल्दी में काम करना है. कितनी बार ये ट्राइब्यूनल जो होगा वो ऑप्शन ई के अंदर होगा, आप लोग पढ़ोगे फटाफट से. मे बी किसी स्टूडेंट ने बहुत सारा टाइम ले लिया हो इससे पहले वाले क्वेश्चंस में, तो वो ऑलरेडी एक बहुत ही जल्दी जल्दी वाले जोन में आ गए हैं, हरी वाले जोन में आ गए हैं. सो इन दैट केस ऐसी गलतियां हो सकती है, राइट. और ट्राइब्यूनल को हम क्या बोलते हैं? एनसीएलटी बोलते हैं. ये तो अपीलेट ट्राइब्यूनल है. Next one, in compliance with the provision of this act, how should a director of the company conduct? What should be the conduct of the director? Director को कैसे अपना काम करना चाहिए, अपनी ड्यूटीज फुलफिल करनी चाहिए? Now this is a very basic question. Very basic question. सो यहाँ पे क्या कंफ्यूजन हो सकता है मेमोरेंडम और आर्टिकल्स में? क्या मेमोरेंडम में कभी डायरेक्टर क्या करेगा वो लिखा होता है, क्या नहीं लिखा होता है? वहां पे तो कंपनी का रिस्ट्रिक्शंस, उनके नेम, उनके एड्रेस क्लॉज और वो सारे रिस्ट्रिक्शंस हो गया, वो तो चार्टर ऑफ द कंपनी होता है, राइट. बट If I talk about director, so that will be covered in the internal rules and regulation of the company. जैसा AOA बोलेगा, right, जैसा articles बोलेंगे वैसे ही director करेगा. Next one, which of the following statement regarding director's office assignment is true? Which of the following statement regarding the director's office assignment is true here? Assignment is not allowed. Assignment is not allowed here. Okay, assignment is not allowed here. It will be void as per section 166, which explicitly prohibits the director from assigning the office, making any such action void. So this is in accordance with section 166. Next one, all the shares in respect of which dividend has not been paid or claimed for 7 consecutive years shall be transferred by the company to which account? Now this is a very simple question, which is Investor Education and Protection Fund, right? Investor Education and Protection Fund. Yes, Shreyansh. In accordance with company regulations, how should a director conduct themselves? How should a director conduct themselves? Again, a very basic question. Promoting the company's objective for collective benefit of the members, employees, shareholders, and community. That's what the work of director is. Right now, these kind of questions can be part of phase 1, but not phase 2. Right? These are not phase 2 relevant questions. The books of accounts of every company relating to a period of immediately preceding the financial year, together with the vouchers relevant to any entry in such books of accounts, shall be kept in good order for how many years? So you need to keep your books of accounts plus the vouchers in good position for how many years? Yes, that is for 8 financial years. That is for 8 financial years. Now this is in accordance with section 128, which is related to the books of accounts. Achha, can you guys tell me what do you mean by vouchers? What do you mean by voucher? What is a voucher? Any idea? We can say that evidence of a transaction, right? Evidence of a transaction. If I buy a t-shirt, the shopkeeper will be giving me bill, right? A document. So it will be an evidence of a transaction, right? It is an evidence of a transaction, and we need to preserve that as well for 8 years. The audit committee is required to be constituted by which all companies as per Companies Act. Acha, can you also tell me the section number here of audit committee? Section 177, right? Section 177. What about the applicability of 177 here? Is it applicable here? What was the applicability of 177? Can anybody tell me? Listed public company is fine. What about turnover? What about paid up capital requirement? What was the applicability of section 177? Turnover should be 100 crore. Okay, 100 crore or more. That's good. Accepted, Nancy. What else? Listed company, turnover 100 crore or more. What else? Paid up capital 10 crore. Very good. Accepted. So can I say that audit committee 177 will apply to you if you are a listed company? If you are a listed company, or even if you are other than listed public company, if you are other than listed company but you are a public company, then in that case, if your paid up share capital is 10 crore or more, if your turnover is 100 crore or more, what was the last point? Loan and debt. Yes, loan and debt. Outstanding loans and borrowings. Outstanding loans and borrowings is exceeding 50 crore. Then also you need to appoint an audit committee. Then also you need to have an audit committee, right? So I will say only option A here is the correct one. Rest are not at all falling in the applicability range. We have seen that in section 177. It is listed company. If it is other than listed company but a public company, then 10, 50, 100 will be the criteria. 10, 50, 100. 10 means paid up capital. 50 means outstanding loans, borrowings, debentures, deposits exceeding 50 crore. And 100 is the turnover requirement. 100 is the turnover requirement. Right, Vaishali. So only option A here will be the correct choice, right? Only option A here will be the correct choice. You need to do some number crunching in the company law as well, because more than concept, it is important that you are able to remember the days, remember the tenures, remember the ROC related filings, within how many days we need to file the documents with the ROC, right? Related to the age, related to the appointment manner. That is more relevant both for your phase 1 and for your phase 2 examination, right? The issuance of sweat equity shares. The issuance of sweat equity shares in the company dash of the paid up equity capital of the company at any time. Be more than 15%, be less than 15%, exceed 25%, not exceed 25%, not exceed 25%, or such higher amount as may be prescribed. This is regarding the sweat equity shares. Option D here is the correct choice. It should not exceed 25%, right? It should not exceed 25%. Now, can you tell me what will happen in case if the corporate entity is a startup, is having a startup status? So what percentage of its paid up capital a startup may issue shares as equity shares? Yes, that is 50%, right? That is 50% from the date of incorporation within 10 years, maximum up to 50%. Perfect. Right? So these are the limits related to the sweat equity shares that we have covered in the course. not more than 50% of the existing paid up share capital, then 25% should not exceed 25%. So this is the maximum limit for a company, and if we talk about startups, then 50%, right? Then it is 50%, and it should not exceed 15% in a year, or 5 crore rupee, whichever is higher. So you may get an MCQ on this line as well. Limits are important. Next one, in the context of the sweat equity shares issued under the Companies Act, what is the relationship between the shares and the equity shares? So here are the 5 statements. Take your time aram se and let me know the correct answer in the comment section. What do you think is the correct answer? This is regarding shares in comparison to sweat equity shares. We are comparing here sweat equity shares with that of normal shares. Take your time, then choose the correct choice. D is the correct answer. Sweat equity shares are having the same rights, limitations, and provisions as of the normal shares, right? Next one, a private company can raise funds by way of what? A private company can raise funds by way of right issue, by issuing a prospectus, by making a private placement, or all of the above, or option E, both A and C. Acha, what is the meaning of right issue? What is the meaning of right issue? What's the meaning of right issue? Issuing shares to my existing shareholders, right? I'm issuing the shares to my existing shareholders. That's what right issue means. What is prospectus? I'm going for a public issue. I'm going for a public issue. Can a private company go for a public issue? No. Because if you want to launch your public issue, then you need to convert your company into public status and not private status. You need to convert your private status to public status, right? Private placement, I am issuing securities to few select individuals or entities, that is also allowed. So option E, both right issue and private placement is allowed for a private company to raise funds. Next one, ABC Limited issues a shelf prospectus for multiple securities offering. Based on the rules under section 31 of the Companies Act, which of the following statement about its validity and filing requirement is false? Option A, a shelf prospectus remains valid for a maximum period of 1 year. Option B, an information memorandum, which is nothing but PAS2 form, we file information memorandum at the time of any further issue, must be filed for any subsequent offer. Option C, the validity period is counted from the date the shelf prospectus is filed with the registrar. Option D, the information memorandum must be filed 1 month before each subsequent offer. So I need to give an intimation 1 month before the subsequent offer, or no fresh issue is required for any offer made during the validity period. Yes, option C and D both are false here, right? Option C and D both are false here. So this is a faulty question here, right? This is a faulty question here, right? Because we have seen that why option C is false. From the date the shelf prospectus is filed with the registrar, is it so? No. It commences from the opening date of the first offer. It commences from the opening date of the first offer. वहां से एक साल का वैलिडिटी रहेगा, राइट? वहां से एक साल का वैलिडिटी रहेगा. And C and D is also false here, right? So both the options are not true here. In which of the following situations is an abridged prospectus not required to be attached to the application form? I am making offer to more than 500 people. That's a general public offer, or is it an IPO, or it's a case of FPO, or in connection with a bona fide underwriting agreement. Now, every time I have to attach a abridged prospectus, but there are certain exceptions that in those cases it will be fine even if I don't attach the abridged prospectus. With all the issues I need to attach the abridged prospectus, but there are certain restrictions. There are certain exemptions in which even if you don't attach the abridged prospectus, that will also be fine. Any idea about this one? Here the correct choice is option E, in connection with a bona fide underwriting agreement. If you have done an underwriting agreement, then in that case it is not permitted. And here are some of the exceptions. In case of bona fide underwriting agreement where shares and debentures are offered to public, are not offered to public in relation to the right issue of the shares or debenture. So in case of right issue also, you don't have to attach the abridged prospectus here, right? So there are certain exceptions in section 33. A member of the appellate tribunal shall hold office as such until he attains, in the case of a chairperson, the age of how many years under the Companies Act? $70 years, right? 70 years. We are talking here about the appellate tribunal. Or maybe there is some issue with the question. This is regarding the appellate tribunal chairperson. Let's have a look. Let me show you that chart which we discussed in the classes. For the NCLT, the maximum age of the president will be 67, but in case of chairperson, NCLAT, it is 70 years, right? It is 70 years in case of NCLAT. And this is one of the most repeated question. Okay, for your examination. So this chart is going to be important. Very, very important, okay? The National Company Law Tribunal is a quasi-judicial body in India that handles corporate matters. The president of the NCLT must have served as a High Court judge for how many years? If you want to become president of the NCLT, you need to be a High Court judge for how many years? Yes, for 5 years. For 5 years. The transfer of securities related to equity, debt, or any other instrument must be completed within how many days of the execution by the company? Here, the question is about transfer of securities. That is 60 days. Okay, that is 60 days. Option C here is the correct choice. For a public issue using a RHP, what is a RHP? How many days before the opening of subscription must the company file RHP with the ROC and SEBI? What do you mean by RHP? Can anyone tell me what is the meaning of RHP here? What is the meaning of RHP? This is section 32, right? Red herring prospectus. Red herring prospectus. And when do we launch red herring prospectus? In case of a fixed price issue or a book build issue? In case of a fixed price issue or a book build issue? In case of a book build issue, right? Because I don't know my fixed price. I don't know my fixed price. Yes, in case of a book build issue, and the correct answer here will be 3 days. 3 days is the correct answer. What are the types of share capital of a company limited by shares? If you are a company limited by shares, what are the type of share capital you can have in your company? That's easy. You can have equity share and you can have preference shares as well. Bond is not a type of share capital. Bond is not a type of share capital, right? Acha, do you guys understand the difference between share capital and capital employed? What is the difference between these terms, share capital and capital employed? Anyone? Share capital and capital employed, what is the difference? Yesterday in the ratio analysis class we discussed, yes. When we talk about share capital, we have equity share capital, we have preference share capital. When we talk about capital employed, it's a wider terminology and it includes share capital. It also have debt in it. When I talk about debt, we have long-term loans, we have debentures, we also do have bonds, right? So capital employed includes share capital as well as debt. That's the difference, right? That's the difference. Though it's a major part of your commerce and accountancy syllabus. What amount is required to be transferred when a company redeems share out of its profits? It is required to transfer an amount to CRR. how much is the amount that we need to transfer to the CRR? Acha, what do you mean by CRR? Capital, redemption, reserve. Whenever you are redeeming capital, when you are paying off the capital, then you need to transfer an amount equal to CRR, which is equivalent to the face value of the shares redeemed, right? Which is equal to the face value of the shares redeemed. Next one. Within how many days can a person file an appeal against the order of NCLT to the NCLAT? To the NCLAT. That is 45 days, right? 45 days is the time limit. Perfect. A company is generally not allowed to issue shares at a discount, but there are certain exceptions, right? Which of the following is one such exceptions? Here are 5 statements. You need to identify the one which is an exception, where I can actually issue the share at a discount. The correct answer here is option C. Option C, right? But ESOPs also discount possible. Can we issue ESOPs at a discount? Can we issue ESOPs at a discount? Anyone? Can we really issue ESOPs at a discounted price? Or is it the sweat equity that we can issue at a discounted price? It is the sweat equity, right? Not the ESOPs. Not the ESOPs. Right? Not the ESOPs. In the exception, the word sweat equity is mentioned, not the ESOPs. All monies received on application from the public for subscription to the securities shall be kept in a separate bank account and shall not be utilized for purpose other than option A for adjustment against allotment of securities, option B for refund of money if shares cannot be allotted, option C when minimum subscription is not received, option D either A or B, or option E all of the above. The correct choice here will be all of the above. If the issue is public, then why you can't use that for minimum subscription, right? So for adjustment against allotment of securities, let's suppose you received some money on application. Now you are adjusting it in allotment. That is also possible. Why? Because maybe the person has given you some excess money. For a refund of money, if shares cannot be allotted, I need to actually refund the money when the minimum subscription is not received, right? So if I didn't receive the minimum subscription, then also I have to refund that money. So all these are nothing but transactions only, and I have to utilize the amount for these purpose only. Otherwise we need to deposit it in a separate account. Isn't option C continuation with option B? So I have taken this particular question from a book. I also feel that option C is nothing but in continuation with option B only. But in that book also they have given this amount separately, this option separately. That's why I have also kept it separately. Maybe there is a printing mistake, right? I have taken this question from ICI material only. बट उसमें भी ये वाला ऑप्शन गिवन था, तो फिर मैंने इसको एज इट इज ही रखा है. बट येस, मुझे भी ऐसा ही लगता है कि इन कंटिन्यूएशन ही है, right? It is in continuation only. Which of the following individual is not eligible to be appointed as an independent director? As an independent director, managing director, whole-time director, nominee director, all of the above, none of the above. Which of the following individual is not eligible to be appointed as an independent director? That's a easy one, right? Yes. All of the above. You can't appoint these directors as independent directors, right? What is the composition of Nomination and Remuneration Committee and Stakeholder Relationship Committee as provided in the Companies Act? Nominee director is a director appointed by any financial institution, right? So again, it's a separate thing from independent director, and for independent director, we need to comply with the whole section and conditions that are related to the independent director, right? Option D, 3 or more non-executive directors, out of which not less than one half shall be independent director, right? Option D. Option D here is the correct choice. Which of the following is generally not available for financing a buyback of a share? If I want to do a buyback of share, which of the following is generally not available for financing? Capital reserve, right? Capital reserve. I can't use capital reserve for the purpose of buying back my shares. And can you guys tell me what is the meaning of capital reserve? What is the meaning of capital reserve here? Generally, in accounting, what is the meaning of capital reserve? Say for example, I sold some asset. I gained something out of it. I was having a fixed asset for 15,000. I sold it for 20,000. So this 5,000 rupees a capital nature profit. It will go to my capital reserve. An alternate director. An alternate director can be appointed to act in place of a director during his absence from India for not less than how long? Now this one we have studied and it's a very basic question, I will say, and one of the most repeated question in examinations. I gave you an example, right? Let's suppose I am going out of India, then in that case we can appoint an alternate director also. That's within 3 months, right? That's within 3 months. A prospectus shall not be a valid prospectus if it has been issued within the what timeline? Options are in front of you. Take your time. Let me know the correct choice. Yes, option C, more than 90 days after the date on which a copy is delivered to the registrar for the filing purpose, right? So if you issue it after 90 days, it will become invalid, right? It will become invalid. Next one. So we have covered this prospectus related thing here, that within 90 days we need to do so. Otherwise, it becomes invalid, right? It becomes invalid. A government company or a company that has existed for less than how many years is not allowed to make a political contribution? 3 years, okay, 3 years. 3 years is the timeline, option D. The tribunal may amend any order passed by it to rectify an apparent mistakes within how many years from the date of such order? A tribunal may amend any order passed by it to rectify an apparent mistake within how many years from the date of such order? That is for 2 years, right? Within 2 years, the tribunal may amend the order and rectify it. A company cannot modify the terms of the contracts mentioned in the prospectus except through a dash meeting and a dash resolution. This is an examination question. This came in SEBI Grade A examination. General meeting, special resolution, right? General meeting, special resolution, option B. Next one. What is the maximum limit of a share buyback as a percentage of total paid up capital and free reserves in a financial year? This is related to the buyback. This is related to the buyback. That's 25%. That's 25%. A company may buy back 25. A company may buy back up to a certain limit, which is set at 25% within one financial year, right? Within one financial year. 10% is for the board resolution. 10% is for the board resolution, right? Here they have asked the question, maximum limit of share buyback. Maximum limit of share buyback, right? If a company fails to pay the declared dividend within 30 days of the declaration, what punishment can be imposed? Yes, that is option E, imprisonment up to 2 years and fine not less than 1000 per day. The correct statement or statements relating to the shelf prospectus are. So this question is about shelf prospectus. A very simple one. A and B, right? Why not C? Because it is valid for 1 year, not 2 year. In case of a shelf prospectus, we don't need to issue a separate prospectus every time. So what we do every time we open we send a information memorandum, right? We send a information memorandum for any kind of issue within 1 year. Within 1 year, whatever issues we are making, we'll be sending an information memorandum. ठीक है? So ये वाला कैसे भूल गए यार? ये तो बहुत सिंपल है तुम लोग. इसके अंदर कॉन्सेप्ट क्या होता है? यही तो होता है कि हमको बार बार प्रोस्पेक्टस फाइल नहीं करना, तो हम क्या कर रहे हैं? शेल्फ प्रोस्पेक्टस फाइल कर रहे हैं और अगले 1 साल के अंदर हम मल्टीपल टाइम्स इंफॉर्मेशन मेमोरेंडम दे देंगे रादर देन द डिटेल्ड प्रोस्पेक्टस. सेक्शन 31, राइट? सेक्शन 31. In a poll, equity shareholders' voting rights are proportional to what? In proportion to always paid up capital, right? And always in proportion to the paid up capital, your voting rights will be there. In the case of government company, the Comptroller and Auditor General of India shall appoint an auditor within a period of how many days from the commencement of a financial year, who shall hold the office till the conclusion of the annual general meeting. So within how many days the CAG has to appoint the auditor here? within 180 days, right? They have written from the commencement of the financial year. That means we are appointing a subsequent auditor, right? 30th, how many directors can be appointed by a small shareholder? That's one only, right? That's one only. The small shareholders can appoint a director who will be representing the interest of the small shareholders. That is one. As laid down under section 413 of the Companies Act, the members may retain his lien with his parent cadre or ministry or department as the case may be, while holding the office as such for a period of how many years? Not exceeding 1 year. Not exceeding 1 year is the correct choice, right? Which of the following best defines the word abridged prospectus under the Companies Act 2013? Abridged prospectus. Yes, option B, it is nothing but it's a summary document, right? Which is having the features of the prospectus. Which city is the principal bench of the tribunal? Is there? And the correct answer here is New Delhi, right? New Delhi. Yes, New Delhi. Perfect.